For several months, the International Association of Chiefs of Police and the National Fraternal Order of Police have been engaged in extensive discussions with the Biden administration in good faith to develop his executive order on advancing effective, accountable policing and criminal justice practices to enhance public trust and public safety. We applaud the administration for listening to our constructive feedback and incorporating our suggestions into the executive order. Our organizations, which represents our nation's chiefs and a majority of the rank and file officers, believe that it marks a significant step in the continuing efforts to strengthen trust between the public, police, and criminal justice system. During our discussion, the IACP and the National Fraternal Order of Police remain focused on communicating the challenges facing the law enforcement profession. We made it clear that our profession is comprised of dedicated individuals who are committed to the preservation of life, maintaining the highest ethical standards, and treating all individuals with dignity and respect while holding themselves and others accountable. Many state and local law enforcement agencies across the country have taken the lead in an effort to make our community safer, modernizing policing practices and making our broader criminal justice system more effective and more equitable. To that end, we stress the need for more proven training, agency accreditation, data collection initiatives that incorporates due process, and more uniform policies based on evidence-based leading practices. Joining us today is Jim Pasco, Executive Director of the National Fraternal Order of Police, to talk about our discussions with the administration and how it helped shape the final executive order. I'm Patrick Hughes, National President of the Fraternal Order of Police, and this is The Blue View. Jim, thanks for joining us on The Blue View. This has been an unusual couple of years for law enforcement, really test us to the limits. But before we get into the executive order and where we are in police reform, for most of our members know who you are, but any of our viewers who don't know Jim Pasco, could you give a little background on yourself?
Yeah, I've been around town a long time. I came to DC on my first tour in 1971 with ATF, now the Bureau of Alcohol, Tobacco, Firearms, and Explosives, and fell in love with DC, which made me almost unique among ATF folks, because most of them either didn't want to come here because they knew better, or spent their whole time here trying to get the hell out of here. But I really fell in love with it, and it kind of marked the rest of my career, because I spent a good deal of it either trying to stay in DC on subsequent tours, or get back to DC when they moved me out. But in any event, my last few years with ATF, I was assistant director for Congressional and Public Affairs, so they taught me a trade effectively. And as I always say, if it wasn't for that, I'd probably be a greeter at Walmart or something like that. But while in that job, a lot of things were going on. The 94 crime bill was in play for a number of years leading up to 94, as was the assault weapons ban, the Brady Law, which ATF was deeply involved in, and so were the police organizations, most notably the FOP. So my first exposure to the FOP was as a lobbying organization, at that time led by Dewey Stokes, who had been president for a number of terms and was just a natural for the Hill. You know, he knew how to get attention, he knew how to keep it, and he made his points in very colorful ways. And so he was very effective for the FOP. And at a point in time, my predecessor, former national president Dick Boyd, who had been very successful in being the permanent in place lobbyist effectively for DC and Washington, started to have some health problems and decided he wanted to go back home. He was from Oklahoma. And out of the blue, Dewey Stokes asked me if I'd take this job, and I told him I would. This was in 94, end of 94, beginning of 95. I said I would, but I'd only do it for 3 years, because I'd retire and I'd work 3 more years and then I'd really retire. And I'm still here for whatever reason. You know, I guess the only thing I can conclude is that I'm really enjoying it, and I haven't messed it up badly enough to get fired.
Well, I got to tell you, it's our win because your relationships here in the Hill and your way of doing business has really served this organization well for all of these years. So, Jim, the last 2 years have been really a challenge for law enforcement. A lot of talk about police reform and a lot of different directions, and the FOP has played a key role in trying to have those fact-based discussions and have a law enforcement perspective on it. You know, in a previous podcast, we talked about police reform and how it's taken shape in the House and then on to the Senate and what happened there, and our role in working with both sides of the aisle trying to come to some consensus to improve the criminal justice system. We also worked on an executive order of previous administration, but really what I'd like to talk about today is the president's new executive order. President Biden just signed an executive order that covers a lot of things, but the journey to get to this has not been an easy one. It has taken quite some time. Can you talk a little bit about when we first started engaging with the administration with the executive order and how it evolved over time?
Yeah, if I may, I'd like to go back just a little bit before that to the closing days of the conversations on the George Floyd bill when it got over to the Senate. And as you know, we had forged a partnership, if you will, with the International Association of Chiefs of Police, and we're working together with the synergy that our two organizations can bring, because they're the largest management organization and we're the largest labor organization. We getting together, we could exert quite a bit of leverage, and so we started there, and we had a good working relationship with both Senator Scott of South Carolina and Senator Booker of New Jersey, and significant progress was made. So when we left off, because the talks finally did collapse, unfortunately, we had a made a good deal of progress, and felt that the work product that we had developed in conjunction with these two senators, both representing their parties in the talks, was a good framework to step out from. Again, unfortunately, it collapsed. So we found ourselves, at loose ends, if you will, on the police reform front. And then the administration decided that, in view of the fact that legislation was clearly impossible, that they would undertake to write an executive order. And early in that process, they asked pretty much all the police groups to get involved in discussions, and we were parties to those discussions. But also, we in the IACP had been asked separately to give our input, based on our perspective developed from working with the Senate on the George Floyd bill, which we were happy to do. And we felt like, here again, we were making good progress. We were working at a high level in the White House with Ambassador Susan Rice, who heads the Domestic Policy Council, and her staff, and Dana Remus, the White House counsel, and members of her staff. And we were moving along. And then at a point in time, a document which turned out to be genuine was leaked to the press. That was a working draft, a White House working draft, which looked nothing like any of the conversations that we had had, and it was far, far beyond anything that we could ever even work from in terms of acceptability. And that caused a huge problem among the law enforcement groups, including us and including the IACP. And we were all ready to walk away. And at that point, Ambassador Rice and Counsel Remus did what they referred to as a reset. And we spoke individually with Ambassador Rice and with Counsel Remus, and they asked us to work with them directly on this and comprehensively, and in a totally off the record and confidential manner, and which you're aware of because I know you took some criticism because people assumed because we weren't saying anything publicly that we were not engaged. And yeah, you probably still have some bruises from that period of time. But the fact is, we had pledged our confidentiality, and they had pledged theirs. So we were all working together, and it really made for more effective conversations and negotiations because nobody was playing to the press, nobody was playing to any constituency, and we started making a good deal of progress. And about maybe a month and a half or so ago, we got to a point where we were down to a few very, very tough issues. Those major details included things like addressing no-knock warrants, chokeholds, the issue of use of force generally, and we found ourselves, almost an impasse. But fortunately we were finally able to work it out. And in one case, we had a product on the shelf, which we felt addressed the use of force issues in a very intelligent way, and in a way that already had the support of the entire law enforcement community. And that was by asking them if they would adopt and consider the consensus use of force principles, which were put together over a period of about 3 years by all the major law enforcement groups in the United States, in a convening called by the FOP and IACP, and we worked with both the White House and as well as with Justice and Homeland Security, because they have the bulk of the federal law enforcement officers in those two departments, although there obviously are some in other departments. And that was found to be acceptable. We also worked out chokeholds in a way that, while they'll be more carefully controlled and in some instances would not be permitted, there still will be provisions to allow for the use of no-knock warrants where no-knock warrants would be mandated by the fact that otherwise there might be a significant risk of life or loss of evidence. On the chokeholds, there again, we had already in an amendment to the consensus use of force document, we had addressed the chokehold issue in a manner which was acceptable to the White House staff who were engaged with us on this effort. So it turned out that we were able to overcome these two significant obstacles, and then we basically had a framework that, with a little cleaning up, which we had to do over time, but no major problems, semantic problems, we were able to turn our full attention to what in many ways is the most important part of the document, and that is the policy statement, the front end, which describes what the reasons for the executive order are, what the goals of the objective of the executive order are, and how the administration intends to achieve those goals. And I used to have a boss at ATF who used to say 90% of getting consensus is in how you present your case. And we felt the manner in which the case was being presented was a manner in which would be perceived by law enforcement officers as picking winners and losers. And guess who the losers would have been? It would have been the law enforcement officers. And again, that was our perspective on it. And we made that very clear. And Terry Cunningham, my counterpart at IACP, who was involved in the negotiations, was a rock on this. And we were also, I should say, we were also very ably aided by staff, both here and at IACP. Gene Vogelin and Sarah Guy at IACP, and Tim Richardson, who many of you know, almost legendary character here at the FOP, and I'm sure most of our members, as I say, already know who he is. But he did a remarkable job in this effort, and we took it into the home stretch only a couple of weeks ago, with a couple of little changes left that we were hung up on in the policy statement, and we finally were able to work those out on a Saturday morning about 2 weeks ago, and we brought it to our bosses, to you, President Yos, and to the president of IACP. They both signed off, and here we are now. The document, we can't. It is not our document. You know, executive orders are the documents of the President of the United States. He signs on the dotted line. So we have to give some credit to his staff and to the President for allowing their goals and objectives to be modified somewhat, as informed by our perspective on these very important issues, very important to law enforcement, and very important to the public that law enforcement is sworn to protect and serve. So here we are, and the document has been signed, and our members need to understand what a great, and I don't mean this to sound like I'm taking credit for it, but it's a great victory for law enforcement here, because while the document lays out a framework for improving the relationships between officers and the communities they serve, and ensuring that all individuals will be protected and served equally, it does not do so at the expense of any of the legal protections or contractual protections that police officers have and need, and are vitally important to continuing to have vigorous, proactive law enforcement by well-qualified, well-trained, and well-equipped officers. So will everybody be happy with everything about it? No. But it's a document that addresses the needs and priorities of the civil rights community. It deals with the needs and priorities of the law enforcement community, and it should result in a greater level of public confidence and safety among the public that we are all here to serve.
Yeah, Jim, there's two parts to this thing, and you've already covered one of them quite well. And that is really is how it's framed, how it's presented. And we know that is not an easy task. And we know that is also something that we were hung up on, because words do matter. And at least in terms of our members, anything after that point, if it doesn't ring a bell or carry something of significance to people, they may look at it completely different, and then everything else is lost in a message.
Right.
So you've already discussed the presentation. The president has a tough job of trying to balance this on both sides, and also have recognize that law enforcement's role. We're 800,000 men and women across this country show up every day in some very bad situations, and make a difference in the lives of so many people. So it's not easy to find words that are going to kind of hit all sides of this issue, and that's a difficult task. The other part is really the meat of what's going on here. An executive order really affects federal employees. It sets a tone for what's expected from the White House and what he'd like to see Congress address. But at the same time, these rules really affect more of federal officers than they do local, with some exceptions. So when you get into the meat of what the executive order is, there are some key things that were important to law enforcement: protection of qualified immunity, the use of force language, Graham versus Connor. All of these things initially were part of the discussion. Can you talk a little bit about how these things have, kind of fit into the executive order itself? And
yeah, well, again, you're correct. You're absolutely right. The executive order is a directive from the president. It is not law, and it cannot have the force of law. Only the Congress can pass laws. So the scope of his authority with respect to directives to law enforcement extends only to law enforcement officers in the departments and agencies in the executive branch. Not and does not include, by the way, any law enforcement officers in the legislative branch, for example, the Capitol Police or the Supreme Court or anywhere in the judicial system where they have their own. The Supreme Court has its own police force, and they won't be covered by this either. But as to the the qualified immunity issue and the use of force provisions in 18 USC 242 and so forth, they could not be touched. They cannot be addressed in an executive order. They could be addressed legislatively, but obviously uh, we were successful on the legislative front in keeping that from happening. So what we have here is a document that will provide a standard use of force policy for all the federal agencies, whether in Justice, Homeland, Interior, or anywhere else, and it will have absolutely no effect on the doctrine of qualified immunity. And Graham v. Connor, again, is a Supreme Court decision, and it still remains the governing guidelines for use of force by law enforcement officers until such time as the Supreme Court decides otherwise. So none of the things that are of most significance to law enforcement officers in terms of their their safety and their ability to defend themselves and the public that they serve will be adversely affected by this executive order. And in fact, what we have been able to do in the executive order is add very, very strong language. Well, the president has added very, very strong language, but we advocated for it with respect to due process rights and any of the proceedings that might occur, adverse actions that might occur with federal officers pursuant to this executive order. That the due process is totally in play, and the action cannot be taken without full due process. A number of federal law enforcement agencies do have collective bargaining contracts, and the U.S. Park Police would be one example. We have a number of military installations where we have bargaining units that we represent. That'll be another very good example. In fact, the Pentagon Protection Force is an FOP local, and it is spelled out in several places in the executive order that nothing can be done that will abrogate the terms of any existing collective bargaining agreement. And that was language that we argued very strongly for. And the IACP, to their great and everlasting credit, very strongly agreed with us on those points. And ultimately, the administration, which is a pro-labor administration, didn't have any problem in accepting them. So basically, you've got an added level of protection with respect to the stability of your collective bargaining rights under this executive order, and the guarantee of due process under this executive order beyond that which you already had. So it actually strengthens employee rights in a number of significant ways.
Jim, let's talk about there have been data collection on officers for use of force for quite some time.
Yeah.
It was also listed in President Trump's executive order. It was discussed extensively in both the House and the Senate in their versions of the Justice and Policing Act. And there's steps within this executive order that collect this data as well. What is different between what has been before, and how does it affect our the members today, our law enforcement officers today, where it didn't affect them before?
Well, I don't think that the average officer is going to be able to detect a very much difference. This language with respect to collection of data and so forth is not very dissimilar from the Trump executive order with respect to collection of data, which coincidentally, we in the IACP also work together on. And the data that will be collected will be data which only applies to sustained complaints. In other words, an unproven allegation or a complaint that was withdrawn will definitely not be included in the kind of data collected. It would only be a sustained complaint. And even then, an officer would have the right to review that data, to contest that data, and to request if there are found to be documents in there that are materially false or misleading, to ask that those pieces of information be removed from the file. And further, officers will be able to include, to counter any adverse effect of that data, information with respect to decorations or commendations or citizen praise to the officer directed formally to the department. So it's not as though this is going to be tremendously oppressive. And again, the average officer will not find it onerous at all, because in all probability it won't really affect them. Now, at the high end of that, and obviously the real tough one is decertification. And decertification is also addressed in this executive order, as it was in the Trump executive order, and as it would have been in whatever compromise came out of Congress, had one come out on legislatively. But the manner in which it's been addressed here, again, first baseline, in my view, the decertification of a law enforcement officer is as grave and serious and terrible to in the sense that it for all intents and purposes ends your career and stains your reputation for life. It's very similar to getting a dishonorable discharge from the service, and it should be treated every bit as seriously, in the sense that before that penalty is imposed on an individual, that individual has to be afforded every conceivable due process opportunity and right available under federal and state law, because you do not want to make a mistake in an area like this and horribly affect the life of an individual unjustly or incorrectly. So every protection that's available has been built into this executive order to ensure that that doesn't happen. However, I think that all of us would agree that if someone has committed offenses so heinous that they should not be police officers, then and they've been afforded all their due process rights and have exhausted them without prevailing, then decertification is appropriate in those circumstances.
Absolutely. One other thing that data that's collected, something that we've had a great deal of discussion on, and I guess a little bit of frustration. Anyone who's dealt with the civil side, civil judgment side of actions, law enforcement officers who are sued for use of force.
Yeah.
There was a lot of discussion about the need to collect data on settlements that were made on any use of force. At the same time, anyone who's been had any type of legal, whether it's a car accident or whatever, knows that often these decisions are not made by people. They never get a chance to be able to defend themselves. It's usually insurance companies that make these decisions.
Yeah.
So I think it's worth clarifying that really the only thing that would be recorded are judgments that come from juries, correct?
That's correct. The officer would have to be actually be tried, in a civil case, and found to have been guilty or negligent or whatever the circumstances provided for before that would be entered into the official record. A settlement is never an admission of guilt. A settlement is a financial calculation by the insurers as to how much they can afford to pay without exceeding the cost of litigation. Right. So it doesn't go to guilt or innocence. It goes to the economics of the case. So That will not be, settlements will not be included in those records.
Yeah, a couple of other things that are in executive order, at least in terms of studies, have to do with the recognition that we're in somewhat of a crisis right now with the amount of personnel we have available for us
Yeah.
vacancies, and it recognizes that it actually takes a number of steps to try and combat that through funds and through grant funding and such. Can you touch a little bit on those?
Yeah, one of the things that it does is address the issue of recruiting and as well as retention. But in recruiting, the federal government is going to use its expertise. And, they're setting up a knowledge lab in the Office of Justice Programs at Department of Justice, which is going to be like a clearinghouse for best practices in a whole variety of areas. And one of the areas they're going to address is effective recruiting, and not just effective in the sense that, if you've got 10 jobs, you get 100 applicants for the jobs. But when you get done with your screening and so forth, that you've selected the right individuals to be police officers. There are some people who can go through life and be gainfully employed in just about any other profession, but if they do not have the unique set of knowledges and skills and abilities that it takes to be a successful police officer. So we will, out of this executive order, get another level of assistance in screening and hiring and ultimately training and putting on the street the best possible applicants for law enforcement.
Yeah, I know we agree on this, and
Yeah.
most people in law enforcement do. Our issue of trying to fill positions really has to do with finding qualified candidates,
Yes.
not lowering standards.
That's right.
Lowering standards only creates further problems. We need to recognize that the steps need to be taken in order to be able to improve the criminal justice system, and it's certainly not going to be by lowering standards. Jim, there are other things that are in this bill as well, and one of them has to do with officer wellness. There's so much demands that are placed on law enforcement officers now, and it's only gotten worse by the manpower shortages and just some of the challenges in a lot of our cities across the country. Can you touch just a little bit on the grant funding that will be available for officer wellness programs?
And again, that was one that we had. Well, there had been legislation introduced by Congressman Trone, and then in the Senate by Senator Duckworth, along with a host of co-sponsors, including Senator Booker and Senator Durbin, both key members of the Judiciary Committee, where the bill would go, that would have provided for funds for officers who were suffering and need assistance, professional operations, run by mental health professionals, with an emphasis on those professionals who have experience as police officers themselves, as our own Sherry Martin has.
Right.
But that will be contemplated in the legislation, which addresses every stage of from initial PTSD through fighting horrible depressions to all the way up to attempted suicide and suicide will all be addressed by legislation. And as I say, this bill is not legislation, but what they can do is provide for assistance in dealing with all those issues, short of the kinds of things that we could achieve through additional PSLB benefits, which, by the way, I have a great deal of optimism we will have by legislation within the next couple of months.
Another issue that I think a little bit of a concern initially when all of this started and the initial version of this leaked out, it was kind of more of a stick than a carrot, having to do with how grants would be awarded, and a concern that in order to be able to take advantage of some of these funds, you would have to commit your agency to do certain things. Can you discuss where we are and what this executive order does in terms of the stick and a carrot approach to grant funding?
Yeah, initially the way the the grant aspect of this was set up, it would have been somewhat punitive in the sense that if you didn't comply with say the use of force provisions, which you wouldn't have had to comply with as a state agency, because again, this only applies to federal officers. Kind of a backdoor approach was being tried where you wouldn't be eligible for grant funding for certain grants unless you complied. So it was a way of forcing agencies not otherwise inclined to do it to take on aspects of this this executive order, or else.
Right.
And what we together with IACP were able to do was convince those that we were having the discussions with that a better way to do it would be to incentivize compliance by making additional grant funding available to those agencies which took on the best practices that were articulated in the executive order, and that was here again after conversations and making the folks from the administration understand that when you take away grant money from a city, it's not the police department that's the loser. Ultimately, it's the citizens who are the losers. And by virtue of the fact that certain law enforcement activities won't be funded and won't happen. So once they understood, where our concern lay, they agreed with us and made the change to an incentive program rather than a punitive program.
As I started, I mentioned that the last 2 years, all of the challenges that we went through and all of the demands that have been thrown at law enforcement. And I kind of feel that some of this has to do with the fact that I think we all have a common goal, and that is to improve the criminal justice system, improve policing. That's our responsibility. When we don't get it right, it's our responsibility to examine it, determine what's wrong, and find ways to correct it. And that's really really at the root of our entire criminal justice system. I think if we look at the last 2 years, at least in my opinion, and I'd love to hear your thoughts on it. The last 2 years, we've seen legislation in states across city councils and state legislation having to do with police reform that are really all over the place. And some of them have been really detrimental. They're having to go back session after session and find ways to be able to fix it because they didn't understand the unintended consequences because they excluded law enforcement in some of that discussion. I'm sort of the belief that the reason why all these states are doing this wide approach to police reform is the inability of the federal government and Congress to do anything that has been meaningful. How do you feel this executive order is going to fill that void since both the House and the Senate since Congress has not been able to get something reach a consensus on police reform?
Well, first, as you know, I agree with you 100% on that assessment. I think that unfortunately, absent meaningful federal legislation, the states and state leadership feels compelled in many instances to take independent action. And with 50 states in the District of Columbia out there, it's likely that there'll be 50 different approaches, 51 different approaches to how to get it right. And sadly, unfortunately, it's likely that at least half of them will get it totally wrong.
Yeah.
So my druthers would be that we would have federal legislation, and that was one of the biggest reasons that we got involved in the discussions on the George Floyd bill. We wanted, as you said, we want to get things right, and we want to be at the table constructively offering our input to ensure, not rather than trying to totally stop the bill, which would again drive the states to want to do their own thing, but to get a bill out that does things the way we think that they ought to be done to best serve the interests of not just our members, but the public that we're out there for. So this doesn't have the force of law, but to the extent that these issues could be addressed within the framework of an executive order, I think it does a pretty darn good job of getting us there.
Yeah, it's certainly been a long journey to get us to this point, and I know it's after 2 years that we've been through. Some people are very skeptical about it, but at the end of the day, what I guess my takeaway is that a lot of the things that are addressed in here were addressed in a previous executive order. What I do like that's in this executive order, there's a much more detailed process for due process and union rights.
Right.
So Jim, I appreciate, and I want to make it, everyone know that we appreciate, this has not been an easy time, especially in a position here in Washington, trying to work through all of these different approaches to criminal justice. But you and your staff have done an absolute awesome job making sure that the rank and file officers in this country are part of this discussion, because we all want the same thing. We want better communities, we want our jobs to be safer.
Exactly.
So thank you and all of your staff for all that you've done. I'll give you a chance to do some final thoughts.
Well, it was a very interesting process. This is, very much akin to the negotiations on the 94 crime bill. Again, this wasn't law, and the 94 crime bill was, but the stakes are every bit as high. And the players on all sides at the end of the day were, focused on getting something done that would work for everybody. And that meant everybody had to give a little, and in return, everybody was able to advance the causes of their respective constituencies. So I'm just happy to have been a part of it, and I hope that it creates an atmosphere for progress that we're all hopeful will be the case.
Time to move on.
Yep.
Time to move past this. Let's adjust, fix, and move forward.
Exactly.
Jim, again, thank you. Thank you for all that you do. And thank you to our viewers. Thank you and our listeners. Thanks for tuning in to the Blue View, where we talk about those things that are vitally important to the men and women who suit up and show up every single day across this country and make a difference in the lives of those they serve. Thank you.
Thanks for tuning into this week's episode of The Blue View, hosted by Patrick Yost, National President of the Fraternal Order of Police. To catch our next episode, be sure to subscribe on Apple Podcasts, Spotify, or anywhere else you get your podcasts. To get the latest from the National FOP, make sure to follow us on Twitter and Facebook at GLFOP and on Instagram at FOP National. Thanks again. See you next time.